Okay, so good morning, everyone, and welcome to this other webinar on data protection and journalism. Today we are here with Jose Antonio Castillo Parrilla, who will talk us about data protection and social media, how to work with social platforms while avoiding lawsuits. So Jose is a member of the Research Excellence Unit, Digital Society, Security and Protection of Rights of the University of Granada, and member of the Chair in Law at the Human Genome of the University of the Basque Country, and many other things that I won't mention here, but I mean, he is researching in this field since quite some time now, so it would be very interesting to explore this issue with him. So before starting, I would remind you that on Thursday at 12 p.m. we'll have the last webinar of this series. It will be on GDPR, so I will send you an email in the next days to as a reminder. Also some quick announcements. I will, when the presentation starts, I will share the link of the practical handbook on data protection for journalists in the chat, in the public chat. And also I will share with you a survey that we have prepared, like a sort of quiz to test your knowledge on data protection and journalism. And in the next days, we are preparing another survey to ask you to like evaluate our handbook and suggest other ways to expand it and make it better, and to be sure to focus to the relevant aspect of this field. So I will send you the link in the next days. I also remind you that you will be free to ask questions to Jose at the end of his presentation. So yeah, I will give you the word in the second half of this meeting. And yeah, without any further ado, I will leave the word to Jose, and while saying thank you to be with us today, please go ahead.
Thank you so much, Federico. I'm so pleased to be here sharing some thoughts and I would say short recommendations on using data and using social networks with regards to the GDPR requirements, just in order to be confident that our activities will not be considered as not compliant with the GDPR requirements and GDPR principles. I'm going to share my screen. Please let me know if it's okay. Okay, great. Well, what would I like to talk about, or what I have been asked to talk about: data protection principles and using social networks, especially if we are sorry, I will stop sharing the screen just to change it. Well, never mind. Okay. Well, on the principles of data processing, just to comply with them. So first of all, what are social networks and why social networks are so useful in many fields, and especially in the fields of research, but not only in the fields of research, because social networks are just, I'm sorry, I'm going to change the screen. Okay, now now social networks are platforms that enable the development of networks and communities of users, sharing of information, interaction, develop, and also allow the development and broaden of communities of networks. Those social networks can also be used for research purposes, and when they are used for these purposes or even other ones, the using of social networks provide many advantages, such as they overcome spatial temporal limitations, they facilitate the involvement of individuals in the activities or in the research. If we are doing research, we can help through social networks to manage this research and to make the results more visible. And also, social networks allow a permanent, dynamic, and diffuse updating of these research results and the activities, since the publications of these social networks are in permanent contact with the society and with the individuals concerned by those activities. So, social networks, to sum up, allow broaden and permanently updated research and diffusing of information activities. But we have to clarify their legal status, and we have to be conscious of the challenges that present those social networks. What are those challenges, and what are the legal status of social networks? First of all, social networks are, from a legal point of view, have a double nature. They are information society services, and they are tools for data processing activities. So, as an information society services, the social networks must comply with the EU Directive 2031, the so-called e-commerce or InfoSoc Directive. As data processing tools, the social networks must comply with the GDPR principles. So, in specific, social networks must comply with Articles 12 to 15, as those articles have been transposed to national regulations, and as data processing tools must comply with Article 5 of the GDPR, bearing in mind that the compliance of GDPR principle must be demonstrable by the data controller, since we also have to be conscious of the accountability principle set out in Article 5.2 of the GDPR. What, what are the main challenges of using social networks from the GDPR point of view? First challenge is the permanent reusing of data. When we introduce data in a social network, those data are meant to be constantly reused. That's why a data controller must bear in mind any principle of the GDPR, but in specific, the purpose limitation principle, the period, the retention period limitation principle, and also the integrity and confidentiality principle. The most important one is the purpose limitation principle in this topic. Why? Because when data are collected for a specific purpose, and data cannot be reused in principle for any other purposes that are not compatible with the original purpose of data processing and data collection. So this principle is very important when using social networks from the GDPR point of view. Second challenge is the legal status of personal profiling and other data. We should bear in mind as data controllers and as data as social networks users that personal profiles are personal data. We will deepen on that later, but I would like to stress on that personal profiles are personal data and should be built as such. Third challenge is the legitimation basis for data processing. This is a very important choice, so it's worth spending time on it. The alternatives as legitimation basis are consent, and also the altruistic consent, that is a very good choice, legitimate interest, and research purposes. Fourth challenge would be identification of risks. The risks are mainly related to harm of individual privacy and harm of honor and self-image. So those risks, depending on each activity, should be clearly identified, and this identification of risk is also an activity that requires time and requires time of reflection with count on each of the risks that we can face. Finally, it's important to take into account that personal data have an expansive nature, and also that algorithms for data processing are most of them opaque, and those algorithms should be a bit more transparent. We will deepen on that at the end. Why I'm saying that personal data have an expansive nature? The key point on this affirmation is when an information relates to an identifiable person. Technological progress nowadays reduces so much the efforts that any person have to take in order to identify some other person on the basis of less data and less accurate data. This has as a consequence that in practice, the idea of personal data is broadening day by day, and then the scope of application of the GDPR is also broadening day by day. With this situation, what cautions should we take just to be easy on the compliance of GDPR? First caution should be that the data controller should assume by default that is processing personal data and act accordingly. That is, it's better to assume that you are processing personal data and take any cautions that can be necessary just in order to be compliant with the GDPR principle just in case. Second, when processing data, a level of granularity in profiling should be defined just in order to protect privacy of individuals that can be potentially linked to the profiles. When personal data are processed, this processing of personal data can be in order to obtain personal profiling, but not necessarily linked to a person. It's important to set a level of aggregation of data just in order to avoid the re-identification of the individuals that provided the original data. Last of the caution to be taken is transparency. Transparency both on the data processing and also on the functioning of the algorithm that will process the data. I will leave to the end this idea of the transparency of the algorithm. Maybe the key concerning when we are about to use social network is who is responsible for these data processing activities. We can take the using of social networks for research purposes as an example, just as a representative example that can be useful. The social network manages a wide range of profiles, data, and many other information. If I am a researcher or a research team, I will want to develop some data processing activities within the social network by the university, that is my university, my research institution, my company is responsible for the activities that I am developing, and maybe I can be funded by a third entity, or I should explain my activities to other stakeholders that are interested in my activity. So the first question that should be answered on that topic is when we are in front of a data controller and when we are in front of a data processor. The key idea is that the data controller decides certain key elements of the data processing. That is, the data controller is responsible for the data processing activities, while the data processor acts on behalf of the data controller, but not decides on that. Hence, the data controller determines means and purposes of the processing, and normally is an organization, not an individual. This last point is very important for anyone that is using social networks, either for research purposes or other purposes. What are the roles then? The social network is a data controller for the purposes of the social network, but not necessary for the purposes of the activities taken within the social network. Hence, we can have different situations of data controllers. We can have several data controllers in the same atmosphere, to say so. The researchers are data processors, but not data controllers. The data controllers will be the university, the company, the research institution, or the newspaper, for example, but not the researcher, the journalist, or any other that are acting on behalf of the entity that is responsible for this activity. Funding entities and other stakeholders are not data controllers nor data processors. Why is it so? Because it's first of all, it's not necessary that the data controller actually knows the specific data processing activities. And more important, universities and companies have the necessary legal infrastructure in order to comply with the GDPR requirements. So those entities are to be the data controllers. Finally, on this topic, we can ask, is there any joint controllership situation? The key point here is that if we are if a joint controller situation is to be considered to exist, both entities must determine means and purposes of data processing activities. This situation should be seen on a case-by-case analysis. But in principle, there will be no joint controllership situation between social networks and the research institution, the newspaper, or the company, since the means and purposes will be determined separately by each one of them. If there was a joint controller situation, it's necessary to register this in a transparent agreement distributing responsibilities and duties of information to the individuals. But in principle, there will not be a joint controllership situation. There is a second key issue to be taken into account, the basis of legitimacy. These bases of legitimacy, as I said, are consent, legitimate purposes, and many others. Consent is the star legitimation basis, both for ordinary categories of data and for special categories of data. It has many advantages. For example, a responsible reporting attitude and greater confidence of the data subjects, and more peace of mind of the data controller with regards to the processing activities. As disadvantages, we can outline the possible lack of information on the processing activities. Hence, we have to bear in mind very carefully the transparency information here, and the consent fatigue, and finally, the special attention to the explainability of the consent when we are dealing with minors. Hence, here, my personal recommendations on using consent as legitimation basis would be provide simple and visual consent clauses, and also take into account that we should provide opt-in and opt-out options of consent in any moment of the processing activity, since it's required by Article 7.4 of the GDPR. With regard to the other basis of legitimacy, 4 points or 3 points should be taken into account. Those other bases must be carefully selected, clearly identified, and well justified. Why? Because with this other basis of legitimacy, we are ignoring the will of the data subject. So we must think on the basis of legitimacy very carefully. Second idea on this other basis of legitimacy would be that those bases are alternatives, not secondary options. I have seen many times when going through a website that this website asks first my consent and second my provides a button for legitimate interest. This should not be. This is not in accordance with the GDPR, since bases of legitimacy are alternatives, not secondary and third options. Other cautions to be taken are related to the anonymization of data, the aggregation of data, the avoidance of identification of data, and also the risk related to the data processing activity. I'm almost finishing now. The last or almost last key point is related to the secondary uses of data and metadata. With regard to the secondary uses, first of all, we have to bear in mind the purpose limitation principle. That is, we should not use data for other purposes that are not compatible with the original purposes of data collection. Second, data commercialization could be considered as a secondary use, but this is at the moment very controversial. So maybe the best option, if there is any purpose related to data commercialization, would be require consent. And on this topic, there is a very interesting tool that was issued by the Data Governance Act, that by the moment is a proposal, that is the altruistic consent. Finally, research is a secondary use that can be compatible with any purpose of data collection whenever the requirements of Article 89 and 5.1.b are met. What are those requirements? Research purpose and data aggregation. Almost last idea. Metadata are very important because they can provide sensible information. So we should take into account, again, the expansive nature of personal data and the expansive nature of the special categories of data when preparing our data processing activities in the social network. On the metadata, there is a last problem, that is that those data, most of the time, are necessary for the purpose of the contract of access to the social network, for example. But here again, it's very important to bear in mind the purpose limitation principle. That is, if as a social network or as an institution, as a company, I collect some metadata that are necessary for the development of the contract, I have to take into account that those data should not be used for secondary uses that are not compatible with this original purpose that allow to collect those data. The altruistic consent is a very, very interesting tool that is regulated by the proposal of the Data Governance Act. And to say it with short words, it's an instrument that allows the data subject to consent not for specific purposes, but for specific fields of research or fields of activity. This is very, very interesting to provide more relaxed by the data of the data controller when doing processing activities. Now, the very last idea on transparency. The transparency principle is set out by the Article 5.1, letter A of the GDPR. That is, the data processing activity must be explained clearly to the data subject. This, from my point of view, but I think I am not the only one here, this implies also that the data processing algorithm should be transparent, since this algorithm is a tool for the data processing activity. Hence, what degree of transparency can we require here? The data controller should publish the main parameters of the algorithm without disclosing the entire algorithm. That would be against the commercial interest of this data controller and also of the ones that developed the algorithm. This is in short words what I wanted to share here. So I remain open for any consideration or any response or debate from now on. Thank you so much for the attention, and as I said, I'm open to any question.
Thank you, Jose. It was very interesting. Lots of hints and food for thought, let's say. So, yeah, before any consideration from my side, I would leave the floor to whoever wants to raise his or her hand and ask specific questions about the presentation or about the topic in general of social networks and data protection. Feel free to have your say. Well, while our participants think about what to ask, yeah, I would say that what you shared is very important, also for the from the journalistic point of view, for the to be aware of the accountability tools that we have against, let's say, the social media platforms. Like, we have to be very aware of what they can and cannot do with the personal data they collect, and the ways they use to earn our consent, people's consent, and so what they can and cannot do in this area. So it is very interesting and very important to be aware of this. And if I could ask you a question, is yeah, from the side of journalists, what do you think about the two things? One is the issue of transparency by the social media platforms in the sharing of the data they collect in some aggregated, pseudonymized, anonymized forms for researchers to research on those data. So what are the issues here on the transparency, on the lack of data that sometimes there is when one wants to research on them? And then the other issue is the process of data scraping that journalists can and usually do to make their research. Is there some problem here? I mean, since data is shared on a social media platform, so anyone can do what they want with this data. Are there ethical and legal issues here? So these are my 2 points, but I don't know if anyone else wants to add some other points so that you can answer to them one after another, or otherwise. Mario, I see that you yeah, go ahead, please.
That last point that you had, Federico, there has been a lot of trouble, I think, last year with some decisions in Spain. I think that was the Constitutional Court that said that if we share a photo, for instance, in Facebook or Twitter, when in social media, that doesn't kind of allow other journalists or other people to use that photo or that information for another purposes, from an economical purpose of the journalist, or if you want to, I don't know, if you want to add something about that, or give us why that's not possible within the data protection framework or so. Thank you, and a wonderful presentation.
Thank you so much for both of the questions. I will begin by the end, because both the question of Federico and Mario are related. There was a very important resolution by the Spanish Data Protection Board in April 2021 that could answer this, but not only because it was on the Spanish Data Protection Board, but because it applies the change of criteria between the Data Protection Directive of 1996 and the GDPR on that point. What happened in that case, and that I think maybe can answer both questions on that. Equifax is a company that collects data that are published by official sources on financial issues. The purposes of the activity of Equifax are developing economical solvency profiles of individuals by this information that is made public. The Spanish Data Protection Board, applying the new criteria of the GDPR, banned this company because this company did not comply with the purpose limitation principle. In short words, it said that not any data that is publicly accessible can be used for any purpose because it's public. It can be used, it maybe can be used, but it will depend on consent of the data subject on each case-by-case situation, but not just because these data are public. This resolution is particularly important since the data that Equifax used were official data published by official sources. So if here the public situation of data does not allow by itself any secondary use, nor in other minor situations, then this change of criteria is different by the GDPR and the previous directive on data protection. This is quite important. And it's also important when we are operating with social networks. I use the research example because it's representative, but we can extend it to journalism or any other situations. Why? If I am using, if I find data in the nature in the digital nature, I will have to ask myself if I can use them for my purposes. It will depend, again, on a case-by-case analysis, but I will have to take into account that the public situation of data is not a sufficient element to decide. But also in journalism, there is an important exception that is quite interesting. This exception is that the data are related to anything that deserves to be published as a new, or anything that has historical or scientific importance. In those situations, even without the consent of the data subject, those data can be used. So this is quite important. These exceptions are in Article 27. I'm sorry to use again a Spanish situation, but I think it's also quite representative, and since it's strong, it can be useful. And 5 years ago, I think, or 4 years ago, when the GDPR was just published, a nephew of one of the components of a court that judged Miguel Hernandez. Miguel Hernandez was a poet that fought for the Republic in Spain. One of the a nephew of one of those members of the court required the data of his uncle to be supreme, to be deleted, in order to comply with the right to be forgotten. Those data were deleted by 5 or 6 days because the university did not know what to do. But afterwards, those data were recovered again because there was a patent interest, both as a new and as historical information. So those exceptions, especially in journalism, are very important. Data protection cannot be a tool to stop the information and to stop the activity of journalism. Then, whenever an information is useful for the journalism activities, the journalism activities that we all know that did not change by the GDPR, the GDPR does not stop the publication of this. The only caution that we should take here is relating this information to historical importance, scientific importance, or anything that deserves to appear in a journal.
Yeah, thank you very much. Yeah, I don't know if you want to add something on what I said before about the like transparency of data for research by social networks.
Yeah, sorry, I forgot this second question. This first question. I think transparency, of course, is very important, and I would highlight 2 or 3 ideas. Transparency means that information needs to be easily findable and easily visible for the data subjects and the citizens in general. That is, we should not make extraordinary and not even considerable efforts to find the information on data processing. Second idea of data processing would be that this information should be explainable. The Working Party of Article 29 issued a guidance on that, but explainability is quite important. That is, the information should be easily understandable, clear, and should try to avoid infoxication. That is, I should not read 20 pages of information on data processing. I have to know the core, just to know what I'm exposed. And finally, I think in order to comply with these requirements of transparency, that the icons, such as the icons used by the Creative Commons or any other figures, can be useful just to provide information of the users. That is, I don't know, secondary uses for research, for data commerce, and this information be provided by simple icons, maybe standardized by the European Commission, can be a good idea in order to facilitate transparency and facilitate explainability of this transparency, since transparency and explainability are two sides or two faces of the same coin.
Great. Yeah, thank you very much. Yeah, so I'd say that if there is one more question, we can take it. Otherwise, I would wrap up here. Let's see. I see that some of you are writing your emails on the public chat. So I didn't mean to have all this personal data shared among us. Just I mean, if you have registered to the webinar, I have your email. So just tell me you want the presentation, and I will send you. So
yes, Federico, if
yes.
anyone wants the presentation, I will send it to you by email. So please share it to anyone who wants.
Yes, please.
You have my consent on that topic.
Okay, great. Okay, so thank you very much, Jose. Thank you to our participants today. I remind you once again that on Thursday, 8th July at 12 p.m. we have the last webinar of this series, which will be about journalism and GDPR, so practical tools to deal with personal data in the European legal framework. So yeah, a bit more general overview. So I hope there will be specific questions to our speaker. And so, well, thanks again, and see you next time.
See you. Thanks a lot.
Bye.